Good morning. We're going to be holding for a few minutes and wait for everybody to sign in. We will be starting at the top of the hour. Good afternoon, and thank you for joining us today. I would like to welcome you to the Fortney Scott's EEO-1 FOIA Briefing. I would like to address some preliminary items before we start today's briefing. Currently, all listeners' phones are muted. At any point in time during the presentation, please feel free to submit a question in the GoToWebinar question box. We will try to answer all questions. Our presenters today are Fortney Scott attorneys Nita Beecher, Liz Bradley, and John Clifford. I will now turn the program over to Nita.
Hi, everyone. We're really delighted to have you here with us today, and I'm really delighted to have my colleagues, Liz Bradley and John Clifford. Fortney felt comfortable enough to let us do this without him, so I feel kind of happy about that, guys. Let's go to the next slide. Just want to open this up and let everybody know, of course, you know who we are. We are the Fortney Scott team, and we obviously have significant experience in this area, and especially Liz and John have recently been doing a lot of FOIA responses to FOIA requests with Ofccp, which they'll talk about in a few minutes. And for those of you who are podcast listeners, we will be dropping a podcast with David and Bert on next week, so on this very subject. So we're looking forward to that as well. And so we're delighted to have you with us. Let's go to the next slide, please. So what we're going to do today is really unpack this unprecedented Federal Register notice that Ofccp put in on Friday with the FOIA request for over 15,000 employers, federal contractors, EEO-1 reports. Then John, who has been doing a lot of research in this, is going to talk about what FOIA is in the background and some really important cases around Exemption 4, which is the exemption that we're going to be focusing on, relying on. Then Liz, who's had a close personal friend, is in Ofccp onto the FOIA desk. We'll be talking about their portal, which is very fascinating. And then in the end, we're going to close out with takeaways for federal contractors. Please feel free to drop questions into the comment box. We are going to try and answer them as we go along, and we're hoping to have about 10-ish minutes at the end to talk about that. So with that, let's go to the next slide. And Liz, you want to kick it off with this unprecedented notice that we had?
Absolutely. So everybody, thank you and welcome thank you for joining us. On Friday, the Department of Labor issued a notice in the Federal Register, and this is a bit of an odd way to do this notification. Many of you out there probably have received notices that your data or something has been subject to a FOIA request. You usually get a letter from the agency. In this situation, they have gone a bit of a broader route. And we've looked into this to make sure that this is sufficient notice, and we are comfortable with that. Under the regs, they are required to give notice that is going to be sufficient to allow the contractor community to know that they're being potentially subject to a FOIA. What the agency has done here is they not only did the registration, the Federal Register, they've placed it on their website. They also used an email blast to the email address that any of the contractors put into their the contractor portal when you registered and you certified your compliance. So the concept here is based on the scope of this request, and we're going to get into that in a minute. This potentially impacts up to 15,000 federal contractors and first-tier subcontractors. So how else is the agency going to ensure that they get the notice out there to the covered entities? It's not by sending out 15,000 individual letters. So they have gone through this route of doing the Federal Register notice. their website notice, and also to the email address included in their new federal, the compliance portal. So we think that they have done a very good job at doing a broad notification. Also, I got we did find out a little bit in advance that this is coming out, and I know we've sent out some client alerts and some other people have sent out client alerts. So the news is out there. So let's get into looking at, if you haven't read the federal notice, Federal Register notice, take some time to look at it. It's got some interesting information that I'm going to spend some time talking through. It kind of lays the foundation of the legal landscape that we're going to introduce John to talk about here in a moment. So who's asking for this and what are they going to do with it? Okay. Not sure I can answer one of those questions, not sure I can answer the other one. So Will Evans from the Center for Investigative Reporting has been submitting FOIA requests to the agency since at least 2019, seeking various iterations of EEO-1 data. His request at one point sought all EEO-1 reports for federal contractors for 1 year. He has subsequently expanded that to have multiple years. He has expanded it seeking specific companies. And so that case his FOIA request has been pending since at least 2019. The notice, and John is going to talk about a case, the Center for Investigative Reporting case, that ultimately wound its way up to the Northern District of California. What happened there is, and initially, OFCC sent out notices, contractors objected under Exemption 4. OFCP only released the data for the non-objecting parties and withheld the data for the objecting parties. Will Evans took that up to court, and John's going to talk about exactly what happened in that case. That case, yes, Nita, please.
I think there's some really good information on the next slide, Liz, that'll support what you're saying for those of us who are visual as opposed to auditory learners.
Sorry, I missed the advance forward cue there. Thank you so much for that. So then Will Evans in early June, based on the status of the California case, which John's going to touch on, has now further expanded his 2019 FOIA request. He is now seeking the EEO-1 Type 2 reports for all federal contractors and first-tier subcontractors for 2016 through 2020. Again, that's approximately 15,000 federal contractors, 5 years of data for those federal contractors. So this is a broad request. In response to that, the agency has done a number of steps. First, they're letting you know about this. They are seeking you to actively engage with them with regard to whether your data is exempt under Exemption 4. They have done this. They're asking you to submit your exemptions, and you are required to do so by September 19. To facilitate that, they have created a portal. Okay, and in that portal, they are asking you to respond to 5 specific questions. And those questions go to the agency's interpretation of what is required to satisfy Exemption 4. So this portal, you need to fill in. It's a pretty basic, easy to use portal. You have to put in company information, point of contact information, some basic who you are and how to contact you information. Then there is a box where you will be able to cut and paste in your responses to the 5 questions. They've also, and in the notice, they also allow you, there is an email address that they have created, a mailbox, where you can also email in your objections. So they've really kind of facilitated this easily, so encouraging you to engage. The notice also, if you look at the language of the notice, they do sort of lay out the legal standards. And a few cases that they cite and resources that they cite. First of all, they do reference a Supreme Court case, food marketing case, and John's going to talk about that in detail, but that is sort of the Supreme Court case that is currently controlling on the confidentiality element of this. They also reference Department of Justice guidance, a step-by-step guidance that talks about whether or not data is maintained in a confidential manner. The guidance and the food marketing case is kind of baked into the 5 questions that we're going to need to be answering. And all of these 5 questions are talked about in more detail later. They also reference, yes, Nita?
We have a question. The question is, was the notice sent to all federal contractors, or were they randomly selected? If certain contractors did not receive the notice, does that mean that their EEO-1 reports will not be released?
Okay, so at this point in time, the way the agency is sending the notice, they've published it in the Federal Register. So that is one method. It's also on their website. And the third way is by sending it to the email address that was included in the contractor portal. So if you have not received the notice, if you have not received it through email or some other written, that does not mean you are not subject to this FOIA. You are subject to it. They are, because of the broad scope of the request, they are taking the position that they're not able to ensure individual delivery of individualized notice, so they're using the Federal Register. Now, one thing that is not, yes, Nita?
I'm sorry, I just wanted to note before you go on is at the end of the slides, we have a link to the notice that's in the Federal Register, so all of you who would like a copy of the slides will have that. Go ahead, Liz, sorry.
Sure. So one thing that's not in the Federal Register notice, nor have I seen it in the portal link, and when the agency has sent the individual notice of FOIA request previously, in that letter, they notify contractors that if you want to get a copy of the data that the agency believes is responsive to a FOIA, you simply need to request it through their FOIA site, and the agency will send you that data. And that'll let you get an idea of what data does the agency have for you, what are they going to be releasing. So it's not in this notice, but I highly recommend that if you have a question about whether the agency has your data, if you're subject to this request, you can reach out to the email address is on one of these slides. I don't recall exactly which slide. I think it's the last slide. The email address about which you can submit the objections, you can reach out to the agency through that and ask them to send you a copy of your data. And that'll confirm whether or not they have identified you as being within scope of the FOIA request.
John, before we move on to do you have any other comments? And then we'll let Liz close out this section here.
Just one comment on that is with regard to Liz mentioned that they were sending notice to everyone who had registered in the portal this year. Obviously, that may differ slightly from who had this information, who was subject to Ofccp jurisdiction during the 2016 to 2020 timeframe. So it could be overly broad. Again, that goes to Liz's point of reaching out, finding out what data they plan to report. I think they're doing the best they can with this massive amount of potential people or contractors involved in this. But I just want to echo Liz's point that reaching out to them if you have any questions is the most effective route.
I think that's a really good point. Sorry, Liz, a really good point, because we know from the Institute the Institute reached out and FOIA'd how many people had actually filed with the portal, and it's only about a little over 10,000. So this is actually going to be a broader number than that. Liz?
So just to wrap up this, and then we can get into the good stuff here. A couple housekeeping things for everybody to remember. If you do not file timely objections by September 19th, the agency is going to release your reports. So that, be aware of that. If you do file objections, the next step is that those objections are then reviewed and sent up to the solicitor's office. The solicitor's office will make a determination about whether they believe you have sufficiently pled that your data is protected by Exemption 4. If they determine that your data is not protected, they will send you notice and the reasons why you're not, and then give you a date by which you can that the data will be released. In that interim time, you can explore what other legal options you have to help to prohibit the disclosure. But those are sort of the operational steps. From what we understand, is in the solicitor's office, the division or department that reviews these is staffed by 3 attorneys. So in addition to their other, FOIA work, they're going to be getting inundated with these objections. So we have no idea and can't even guess how long it is going to take for the solicitor's office to review those objections, but we do not think that it is going to be a rapid project. So we think that there may be a long delay between filing of your exemptions and ultimately determining whether the agency is going to choose to release your data. And with that, I'm going to turn it back over. I've gone a little long on my section, so I apologize. I'm going to turn it over back to Nita to lead off the legal background.
Well, I'm actually going to make John do all the work on this one. So, John, we've been talking about FOIA. We've been talking about what it is. We talked about a couple of cases. So let's, very few HR people or in-house counsel have to deal with FOIA very often. Can you kind of walk us through and take us to the next step of what is FOIA, the legal background, and then the cases that are really pertinent for contractors?
Absolutely. Thanks, Nita. And as Liz said, I will note again that the notice does have a lot of very useful information, and it does walk you through many of these cases, or at least point you towards many of these cases or laws that we're going to be discussing today. We're going to try to give you a few more details to show you how these may apply to the situation that contractors are faced with here. So before we dive into the specifics of the potential objections to these requests, just a quick overview of the FOIA, the Freedom of Information Act, which was enacted back in 1967. It is intended for the public to have a right to request access to records from any federal agency. Again, the purpose is to provide access. I just want to point that out here. So federal agencies, when they receive these requests, they are required to disclose this information requested properly under FOIA, unless it falls under one of 9 exemptions that are included in the statute. Those exemptions can cover a range of things, such as classified information, personal privacy, personnel files, for instance, anything, as you might imagine, that involves national security or foreign policy, records related to law enforcement. So there's a wide range of the types of exemptions that agencies would not have to provide. The one we're going to be focused on today, and that Liz noted, you see up here on the screen as well, is Exemption 4. The notice points to this. That's what the Ofccp says. They have reason to believe this may apply to the information being requested. Exemption 4 protects from the disclosure of trade secrets and commercial or financial information obtained from a person that is privileged or confidential. So it's a short sentence, but there's a lot to unpack from that exemption, and we're going to spend the next few slides doing just that. So if we can go to this next slide here. And I know the text is a little small, but this is a useful slide from the Department of Justice, which has a lot of guidance and FAQs available on the various exemptions and FOIA generally. And while it does restate the language that I just read here, one point that it makes clear and that we will dive into further here is that this exemption does cover 2 distinct categories of information. One, is it a trade secret? Does it meet the definition of the legal definition of whether or not it's a trade secret? If not, if it doesn't rise to that level, it can be exempt if it is commercial or financial information that is privileged or confidential. So this is the focus today, whether the information being requested, these Type 2 EEO-1 reports, can be considered commercial or financial information that is privileged or confidential. So this, again, not a whole lot to it just on its face value here, but it's been the subject of quite a bit of litigation. It's been referenced in the notice. Liz touched on some of these, but we're going to dive into two cases, the first being a Supreme Court case that have clarified how potential objections can be made under Exemption 4 here. The first, Liz mentioned, is Food Marketing Institute v. Argus Leader. This was a 2020 Supreme Court decision that addressed the requirements to satisfy Exemption 4. Really, it was focused on one piece of Exemption 4, and that is whether the information is privileged or confidential. What does the government or the defendant, in this case, what would a contractor have to show that the information is privileged or confidential? And I'll give a brief background of the facts of this case because it does help understand how the court arrived at their decision. Argus was a newspaper based out of South Dakota that submitted a request all the way back in 2011, although this decision wasn't until 2020, to the U.S. Department of Agriculture. They were seeking information provided to the agency from retail stores. Just a point here, this information differed. It was not EEO-1 information, but a lot of the reasoning will still apply here. This was information regarding benefit payouts for food stamps, in fact. The USDA, citing Exemption 4, refused to disclose the requested information. Argus then filed suit. In both the district court and then in the appellate court, held that this information, in fact, did not meet the requirements of Exemption 4 and that it was not confidential. Their reason being that the government had not shown and what they referred to as a likelihood of substantial competitive harm resulting from the disclosure of this information. Now, you may be looking at the language of Exemption 4 that I read you and wondering how they decided this case based on a substantial competitive harm standard. And this was actually something that had developed in lower courts and actually was based out of the DC Circuit going back to 1974. There was a line of cases that essentially determined that information under Exemption 4 could not be deemed confidential unless there was a showing of competitive harm related to its release. So once this was decided and the Food Marketing Institute got involved after the USDA lost at the lower levels, they petitioned the Supreme Court for review. And when it went up, the Supreme Court, they agreed with the Food Marketing Institute that there was no basis for applying this substantial competitive harm standard. They went back to the plain meaning of what is stated in the exemption of whether it is privileged or confidential information. And they determined, they actually got right down into it and said, how do you know if something is confidential? And they said the standard meaning is, does the person whose information it is, do they customarily keep that private? In this case, they found that this information was customarily kept private by the retailers that were being asked to disclose it. They also addressed a second element here, which was if it is disclosed, for instance, if you're required to disclose it to a government agency, do you have assurances that it will remain secret? So you're not just giving this information to anyone who requests it, but only to people who will continue to keep it private and confidential. A note here, the Supreme Court left a little room for how these assurances have to be made, whether it has to be an express written assurance or can be implied by practices. In this specific case, the retailers had received that assurance from the USDA, so the Supreme Court said, that's good enough, we don't need to get into every which way assurances can be made. But what they were very clear about is as long as it's kept private and you have the intention of keeping it private, there is no requirement that you have to show that competitive harm, that substantial competitive harm, that again was dated back to the 70s, coming out of DC. Now, I mentioned that this case was decided in 2020. I will throw in here, you can see in the bottom of the screen. Yes, Nita, did you want to?
Liz, I think has, two things. One, go ahead, Liz.
I was just going to tease in everybody, listen closely about John's references to the DC court and reliance on DC courts from the 70s. That's going to be a theme we're going to coming up here for a minute. So I just wanted to tease that out, make sure everybody was listening to that for a second.
Mm-hmm.
The other thing, John, is listen very carefully to how John said that some of the items that you use to decide whether it's confidential, whether you got those promises. You're going to see that question show up later on. John, go ahead.
And I'm going to give you an answer to that question.
Absolutely. Yeah, Liz will circle back on that one. Absolutely. So we think we have some clarity from the Food Marketing Institute on whether harm is required. Of course, it can't be that simple. There's a little bit of a wrench thrown into that here. There was an amendment to FOIA back in 2016. Now, of course, that's before the Food Marketing Institute, but remember I mentioned that the actual requests for the information in food marketing were way back in 2011. So they preceded this FOIA amendment. And the Supreme Court didn't address it. It wasn't a part of that case. But what that amendment did touch on or added to FOIA was that for any exemption to apply, the government agencies can only withhold that information if there's a showing that the disclosure if there's a foresees that the disclosure, and I want to emphasize that they foresee that a disclosure would harm an interest protected by the exemption. Now, obviously, this seems to add the harm element back in. I just want to touch on one point or a couple points with regard to that, because it is a little different than what they were addressing in Food Marketing Institute. Again, in this case, it is a reasonably foreseeable harm. It does not have to be, as in food marketing, it was a substantial competitive harm that you had to have a showing that that would occur, and that's in our opinion a higher burden than what accompanies this amendment here. The type of harm and the how far-reaching that harm could be to a business or a contractor in this case. But it is something that we do want to mention, and certainly the next case we'll talk about made clear that this does have to be addressed, even in light of the Supreme Court's decision in Food Marketing Institute. So with that, we can go on to the next case here. Next slide, excuse me. And this is another case that's cited in the notice. The Center for Investigative Reporting, Liz gave you a little bit of background on this, on what the requests were and how it ended up here. And I do want to note, you don't often see that you get some pretty straightforward decisions from the Supreme Court, and then you follow that up with a district court case. And I'll touch on this a little later on why we're addressing this, but the straightforward reason is that this case is, as Liz noted, directly on point to what we're dealing with here. It was the same person requesting the information. It was the same type of request. They were the Type 2 EEO-1 reports were being requested, albeit in that case for only a single year as opposed to 5 years, and for a much more limited group of companies. I believe that request was for 55 companies. And the government only ID'd up, I think, 36 or so of them as actual contractors under their jurisdiction. So, but the type of information is the same. The objections under how the objections and how the court interpreted the exemption and application of the exemption under Exemption 4 is going to be instructive on how this is addressed here. So again, I'll just go into a little bit of background. Here at summary judgment, the district court found that the EEO-1 reports did not satisfy Exemption 4. The Ofccp and Department of Labor had denied the initial request, but at summary judgment, the court found that they did not satisfy the Exemption 4 and ordered that the reports had to be provided. In food marketing, the case we just talked about, the Supreme Court decision, and we found this interesting, Well, the focus of the Supreme Court there, and really the argument, was about whether or not that information was confidential and privileged. And that was really the burden that you had to get over here. And they really overlooked the first part of Exemption 4, which it has to be commercial or financial. That is the issue that this case turned on. Whether the information requested, the EEO-1 reports, can be deemed commercial or financial information. So with regard to that, the Department of Labor argued that the reports, the EEO-1 Type 2 reports, these are the consolidated reports, that they are commercial in nature because they relate to the contractor's respective business strategies, and that they could cause financial harm to the companies if this information was released. They submitted a number of declarations in support of this, and those declarations included concerns with regard to the information that was being released, showing their labor strategies, their demographics, potential recruiting and allocation of resources across their business segments. And they also raised concerns that revealing this information could open up these contractors to vulnerability in having their diverse talent poached from other companies. Once this information was out there, they could see who had the diverse talent, where it was, and they could go after that, target them for recruiting and poaching. The court, after reviewing the declarations and hearing this information, they touched on a few points and ultimately ended up determining that they did not find that the EEO-1 reports were confidential. They found that generally information is commercial if it relates to commercial activity, as you might expect. That's a very broad interpretation. But then they added a caveat there that not every bit of information submitted to the government by a commercial entity qualifies. Now, you may ask where they got that information from because it's not included in Exemption 4. Well, they're going back to, as Liz said with the T's, the DC Circuit. And in the same time frame that created that substantial harm, this comes out of the 70s and 80s from the DC Circuit. So you have a court in California, and the only place they can find to support this sort of narrowing, this qualification on commercial information, is the same circuit from the same period that just got, pretty directly overturned by the Supreme Court. Nita. Yeah.
I would say now, this particular district court, they were only looking at 1 year each for these companies. I'm hoping that 5 years or more of data, because he keeps adding, the longer it takes them to review these, the more years I think they're going to add. I'm hoping that trends, and Liz and John, what do you think about that? That the trends here might be commercial.
Exactly, and right, and when we get into talking about what those questions are, Nita, exactly, there's some additional data that we can allege and that we need to be asserting when we're responding to these questions. Absolutely.
Yeah, Nita, and that raises a good point, because one of the reasons I wanted to provide the details on this, and we're not taking this court's decision as gospel here by any means, but you do want to see the points that they disagreed with. How can we differentiate and distinguish our objections from those that were already made? And I know Liz is going to touch on that further after we get through the nitty-gritty of these cases here and get into how do we approach this. So I'll just make a few more points on this case as they got into it. So again, based on this information, the court really decided that the EEO-1 reports, that they only provide the composition of the workforce, as we all know, by gender, race, and ethnicity, by these broad EEO job categories, and that those don't rise to the level, they don't include information about staffing levels within departments or divisions. They obviously don't include sales information, compensation, things of that nature. And that's what the court relied on to make this decision. Again, what authority they relied on to say they're cutting this off between divisions and segments versus EEO categories for distribution, there isn't any. It's just this sort of, they come up with this, they fashion this opinion based on this really sort of surprising, I think, to a lot of people, focus on whether the information is commercial and this narrowing of commercial information. two more issues here. Because they decided that the information was not commercial, they did not get into whether it is confidential. If it's not commercial, it doesn't matter if it's confidential, but they did note that if they were to address that, some of the contractors involved in this case may have issues showing confidentiality if they had, for instance, one contractor had put out a summary of their EEO-1 data in their annual report, a pretty detailed summary. Or of course, anyone that had released this data previously. So they sort of give you a blueprint of things to be on the lookout for when we do address this issue, if you are to object to this issue. And again, they didn't address the foreseeable harm under that 2016 amendment. What they did do is say that you would have to make a showing in order to succeed. They didn't get there in this point. The government actually didn't make a showing in this case. They were relying incorrectly on Food Marketing Institute. But again, they were sunk on that commercial information and really this narrowing of that. And my final point on this, because I know I've touched on DC law, the DC circuit, and I'll go back to the Supreme Court on this and food marketing. When we're looking at the DC circuit, there's statutory interpretation that's driving all of this. The Supreme Court referenced as a relic from a bygone era, which I think is pretty on the nose there in this opinion. So, and that will come into play in these objections. So that was a lot of details on these cases. I'll turn it back over to Liz on this moving forward.
Sure.
Before we go on, I'm gonna move us to that in just a second. I do think it's important, John and Liz, to remind everyone that even though we have this one decision, it has not been. Went up to the Ninth Circuit, and the Ninth Circuit basically said that they didn't appeal in a timely way. They did not confirm this decision. So it's basically just a Northern District of California case. But because it's the same people, it's the same person, Will, you can imagine that he's going to push this really hard against the Department of Labor. So let's go to the next slide, because Liz, are you ready to talk about the OFCCP submitter notice response portal?
Absolutely. All right, let's get into this. We can go on to the next slide. So here are the 5 questions, drum roll here. So these questions are really getting at the questions of, is it commercial? Is it confidential? And what is the potential harm with a foreseeable harm, right? But let's kind of walk through all these. And to Nita's point, what I going to hit on response to number 1. Do you consider the information from your EEO report to be trade secret or commercial? Yes, you're going to say yes to that, right? Do not be deterred by this one case in the Northern District of California that had to reach across the country to DC and down 40 years to find cases that support their determination that it is not commercial data. So even the reasons that are cited that the Northern District Court has rejected, we are going to reassert, because we still believe those, just because they have decided that it is not sufficient to be commercial. I don't necessarily agree with them, and any other courts may not necessarily agree with them. So I don't think, if anybody's thinking, well, gosh, that case was lost in the Northern District, do not be deterred by that. To Nita's point that I make, that case was not blessed by the Ninth Circuit. The appeal was dismissed purely procedural, purely for lack of jurisdiction because of the untimely filing of the appeal based on the Ninth Circuit's finding. So they have not come down. And it's important to note, the agency in the Federal Register notice put a footnote in and expressly added that in that says the dismissal of the case was on procedural grounds. So the agency is even acknowledging and recognizing that there may be room for them to consider that your EEO-1 reports are commercial, because your audience right now in the initial blush is the agency. Now ultimately it could be a court if Will Evans appeals up again. But so we need to be looking at that, and we need to be thinking about, how does the data in your EEO-1 What does it show about your business? That answer is going to be different based on each one of you listening in, based on the size of your business, your workforce population in each of the categories. So you need to be thinking about that. But we absolutely think we need to be putting forward that this is commercial information and not be deterred by the CIR case. Another question is even applicable? Do you have employees in Northern District of California? Is that case even ever going to be, it could be, instructional for opinion, but would you ever be before the Northern District of California? The next questions talk about is the data customarily kept, this is the confidentiality, kept in private and closely held? Well, I would assume most of you are going to say yes to this. How many of you keep your race and gender data in your HRIS segregated off? You need to be looking at that. Now, first of all, we're going to assume that if you're not releasing your EEO-1 reports. I'll kind of caveat here, if you are putting your EEO-1 reports out there and you're public, you are likely not going to qualify for Exemption 4. You have put the data out there. So all of this discussion is an assumption that you have not already disclosed your EEO-1 reports out on your websites and other places. But one of the pieces I want to spend some time here, because we all have a great, do you contend that the government provided an express or implied assurance? Well, yes, we do. If you go to the EEO Joint Reporting Commissions, and I'm going to read right from it, it says, all reports and information from individual reports are subject to confidentiality provisions of Section 709 of Title VII. Goes on to say, any EEOC employee who violates this prohibition may be found guilty of a criminal misdemeanor and could be fined or imprisoned. I think that's a pretty solid leak-proof assurances and reason to believe that when we're filing our data with the EEOC, and we are disclosing that, and our contractors are disclosing that to the EEOC, we have those assurances. So I think question number 4, I think most of us are not going to be answering, because we're going to be saying yes to number 3 and that we have those assurances. Let's move on to number 5 for a minute. We're revisiting this harm, the swaying in and out harm standard. The agency is asking us to respond in the portal. Do you believe that disclosure of this could cause harm to an interest protected by Exemption 4? Then they add, and that's pretty close to what the FOIA amendment says, is there, is it reasonably foreseeable that there could be harm? But in parentheses, the agency takes, I think it's a step further and heightens the standard here. And they're saying, such as by causing genuine harm to your economic or business interests. I'm not sure what genuine harm means or how they're defining that term. Not exactly sure where the term genuine harm comes from. But to the extent that they are expecting you to provide proof of harm or quantify it in some way, I think that's going to go above what the FOIA amendment requires, is simply that you can articulate reasonably foreseeable harm. Yeah, Nita.
So Liz, you've had the opportunity subsequent to the California case to have a number of clients come to you and ask you to file objections to FOIA requests, because Will has been, and other news outlets have been very busy trying to collect EEO-1 data. Is this question the same as the ones you've had to answer before?
No. No, and that's what's interesting here. And this is the other thing why I think, while it is very useful that the agency has put the portal up and they framed out these questions for us, and we're going to get to some of our recommendations, I'm not sure that the agency always hits directly on what the controlling law is. So these may be questions helpful for them when they're making their decision. But if your exemptions are honored and this gets appealed up to our court, is the court looking at the same standards the agency is going to be looking at? So for example, most recently, there was a FOIA request, I believe the letter was sent out in 2001, that actually in the parentheses, it said such that would dissuade others from submitting the same information to the agency. And that phraseology was referencing back to one of the prior cases, sort of that back to the substantial harm cases. So the agency's FOIA letter, what they asked, hadn't been updated based on the developing case law. So while these questions are very useful to the contractor community, I would kind of take a pause, and I think you do need to go back and look at what are the courts going to look at, and how do you need to answer this, not just for the solicitor's office review, but ultimately if we are in a court. So again, so looking at this and consulting with your counsel about how you need to really establish Exemption 4 coverage.
I think that's right. John, anything else you want to add before I go on to the FAQs here?
No, I think Liz touched on that. I agree. I think that the question number 5 there is a bit of a catch-all. They're trying to cover their bases with that parenthetical at the end there. But agree overall. I think these questions are very helpful to the contractor community.
Well, in the let's go to the next slide. On the portal, I should say, they have a bunch of information in addition to what we've been talking about. And I think one of the most important things is this is really what they are seeking, what Will is seeking here are your consolidated EEO-1 reports, not all the little ones, because I think he would really have a hard time. You would really be able to show harm. You would be able to and that is a little bit more what the Supreme Court case was talking about, where they were trying to get data from individual stores. So they're not this is your big company one that you do. The other thing that's confusing is that it looks like that, you got component 2 and type 2. Component 2 is not covered. Component 2 is our pay data collection from 2017 and 2018. I'm not even sure Ofccp at this point has that data. They have decided to accept it, but I don't know if they actually have it yet. Now, it's really important that if you don't care, if you don't mind releasing these, you don't have to object. This is only for people who don't want to release their EEO-1s. But if you don't object, they will release them under the statute. And if Ofccp determines that they are going to release your reports, even though you filed objections, they will let you know. They will notify you as a contractor. But turning to what we think contractors should do, Liz, going to the next slide, you want to take us through that based on your experience as a skilled objector to FOIA requests.
Thank you for that. So yeah. I mean, first of all, you need to review with counsel each of the components of the Exemption 4 requirement. Make sure your data is confidential, right? Look at that. Where are you sharing the data? Make sure you're not sharing it. Don't know you're sharing it. Look at the commercial use of it and make sure that, because you're going to need to be very detailed and give clear reasons why that you meet the standards of Exemption 4. So there's a lot of standard language, but we want to give real examples and be able to articulate specific to you. We're recommending that you do complete the portal process, but I want to talk about why I think we need to go a little bit beyond that. And again, filing the portal is fine if that's what the agency, and I'm sure the agency consulted with the solicitor's office, and that's all that they need in order to review. But those are boxes, cut, paste box. All you can put in is your assertions. You cannot upload anything. So one of the things we looked at, and the California case looked at a lot, is they reviewed the declarations that were submitted by the contractor community in support of each of their exemptions. They really relied on those heavies. They quoted them. Now, they didn't agree with them in their quoting, but it did evidence that the court was looking at more than just the bald pleadings or the bald assertions. They wanted some factual support behind those. There's no mechanism to do that in the portal. So we are highly recommending that the contractor community do detailed exemption letters that addresses not just the agency's 5 questions, but I think we need to go in and talk about the potential challenges to the California case and show why we do not think a bold compliance with that standard is appropriate and why it may not be applicable to your environment. We also think you need to be giving that detailed information, declarations from who's maintaining your applicant or your employee data, race and gender data, where is it maintained? Who's maintaining your EEO-1 reports? Is it the same person, same declaration? Great. If not, do you need multiple declarations? You need to have that factual support for all of the detailed reasons why you maintain the data and it's confidential. Cite the fact that you relied on the assurances from the EEOC when you file your EEO-1s, that you are relying on those assertions of confidentiality. I think there's also rely on how many of you out there have received these FOIA requests in the past and successfully asserted an exemption 4 challenge and were successful at that. And then the next year you filed your EEO-1s because you are on further reliance that not only will the EEOC keep those confidential, but Ofccp is going to respect the confidentiality and commercial nature of that data through its application and acceptance of Exemption 4. So there's a lot more that needs to go into these exemption letters than I think they fill in the box that the portal allows. And the portal does have an option at the bottom, say anything else we need to know, and you can simply refer the agency back to the letter that you're submitting through the website portal of the same, and let them read them together. John, yeah, please chime in.
Just to tack onto that, Liz, I think in the Northern District of California case, the court really did take issue with the fact that some of the information they received about why it was commercial was a little bit generic, didn't really get into detail there. So I just wanted to go back, emphasize your point about really looking in and giving detailed responses here, because I do believe that could be significantly more effective at taking what we've learned from that California case here.
Ida.
There's another problem, yeah, Liz. There's another problem that the people we're talking to may not be aware of, but there's been a big push by the ESG people to get employers to publicize their actual EEO-1 reports. So make sure, if you've done that, it looks like I think you're in trouble to claim confidentiality. And whether the California, if you summarized it, that may be a little bit different. They claim that they would not find it confidential if you even summarized your EEO-1 reports. I wonder, I throw this out to Liz and John, confidentiality if they have put up a summary of pay data, for example, men versus women, which many people do. I wonder if that would be problematic.
I think we'd have to look at what they made public and compare it to what was in the EEO and how they made it public. I don't, hard to opine on that without actually seeing it, but I do think strategy point here. If you, like we mentioned before, I'm not sure how quickly the agency is going to be getting through these exemptions. So I think there is benefit in filing the exemption. What you as a company are going to be doing this year, next year, in response to shareholder pressures, about releasing some of this data, maybe ultimately you end up disclosing some of this data. Then you're going to be disclosing it and you're going to control the disclosure. You'll put the necessary context around it, etc. So you can meter the flow of data, where if you just don't object and just say, oh, we'll probably lose on this, then you're just consenting to Will Evans getting your data and gosh knows what he's going to be doing with this. So there's, I still think while it may be a close call on some of these things based on what you do with what data you currently disclose, unless you're posting your full EEO-1s, but if you're disclosing some data, maybe a close call, but I still think that there are benefits to filing the objections. putting a pause on the release of your data, and then you can internally strategize about what you're going to be doing and how you would address the ultimate disclosure of the data if you think that's going to be the result.
Liz and John, I think it's important just to make this one last point, that yes, you should respond through the portal, but in order to have your best defense, you should also submit a letter. You can say additional information in the additional information box that you are also submitting a letter with a declaration so you can speak more clearly about your particular situation. Any other thoughts around that before we conclude with questions here? All right. Well, we have a few minutes. Let's just go to questions. Let's go to the next slide. I just wanted to show this before we go to questions here. The next slide, we have within the, as we mentioned earlier, we've got the notice. You can click on that and get the notice. We also have how you get to the portal. You click on the next item. We also have access to the FAQs, and also, as John mentioned, there's DOJ guidance on FOIA, and within that is also on Exemption 4, specifically, just so you have that as part of your discussion as you talk with counsel. And backing up to questions. So, thinking about this, John, what do you think is the most important thing for people to do between now and the 19th of September?
I think the immediate next step is absolutely reviewing the data. This goes back to Liz's point, reviewing the facts specific to your company, figure out, first of all, what has been put out there, if anything, with regards to this data, how it's kept. If it hasn't been put out there, what steps are taking to make it confidential. And I think start working with in-house and with counsel to start developing the issues that you may face. Companies of various sizes are going to have to respond to these different trends. Certainly it can affect, show different things about different companies, but the commercial aspect of this and essentially outlining why this fits under Exemption 4.
Exactly.
And Liz, I think you've got probably all of us, you've got the most experience in actually dealing with these. Have you been successful after the Northern District of California case in FOIA objections, and how have you done that?
So we have been successful. I mean, I would pause for a moment though. Is one of the after the Northern District of California case, the district court issued while it was pending, OFCCP did adopt the questions out of the Northern District of California case and applied that to FOIA requests. And we responded to it, but said, hey, it's a little premature for you to be accepting these questions as controlling when the appeal is pending in the Ninth Circuit. So wisely, I think the agency did choose not to move forward with releasing contractor data based on the opinion in a case that was actively being appealed, right? So those exemptions were upheld, the data was not released. How is the agency going to feel now that that opinion is essentially in force in Northern, the appeal is over and that case is on the record and they have said that it is not commercial data? I don't know how the agency is going to take that. Between the tea leaves here, I think that if they were just going to accept on its face that EEO-1s are not commercial, essentially accept the Northern District holding, I don't know if they would have gone through the efforts of a portal and the FAQs, and they're really inviting the contractor community to engage on this and submit their exemptions. So, again, I can't speak for the agency, but I'm getting the impression that they may not just accept that the Northern District opinion says this is not commercial and that's the end of the story. I think the agency and the solicitor's office is going to do their own review of these exemptions and make some determinations, and possibly let's see what other cases may filter up.
I think that's probably right. So we're almost at the end, so I think this is probably a good time because I know people have to run to other meetings. And so thank you, Liz and John, very much. And we're going to pass it off to Valerie to close us out here.
We would like to thank you for joining us for today's briefing. At the end of this presentation, you will receive a survey requesting feedback for today's webinar. You will also be able to submit suggestions for future topics through the survey. For more on topics such as today's presentation, please listen and subscribe to the DC Insider's Employer Update podcast. You can find that podcast anywhere you listen to podcasts, and you can also access the latest episode on our website at www.fortneyscott.com. Thank you again, and of course, if you have any questions, you may submit them via email to info@fortneyscott.com.